Hey, Andy Nelson. Some of you may recognize this from yesterdecade, right? This is one of the California raisins, if you remember those commercials. If you saw those commercials back in the day, I had happened to have this in my vault, I guess, if you will, a kind of a collection of things that I've just saved over the years from my childhood. At least I hope I had this when I was a kid. Um, Look at something like this. It's a figurine, right? It's just a rubber toy. It's not really an action figure, but it's a thing, right? And you look at this. Let's say you were thinking about something like this: a figurine, an action figure, a doll, plush toy, what have you, and you are wondering how might you protect that your creation, or can you protect your creation? The fact is, yeah, you probably can. And that sort of thing, this kind of thing right here, would typically be covered by copyright law. Copyright law protects expressive works, including sculptural works, and that's kind of where these sorts of things fall in line. There, it's not. We're not talking about Michelangelo here, but nonetheless, it's kind of a sculptural work in a way. It's a three-dimensional expressive work. Now, funny enough, this company right here, right on the foot, they actually tell you there's a copyright on it. They're claiming a copyright. It says right there, copyright. It has the circle C, 1987. Guess that's when I got this, roughly, something like that. But let me say, there is another protection here, most likely, and that would be a trademark. And how? Why? Because a lot of you recognize this right away as one of those California raisins. And the company, I'm not sure if it was a company or a collective or what have you that sold the raisins, but the California raisins was kind of a recognizable thing that was associated with that industry, right? So these figurines, even though this right here is a three-dimensional little toy, we saw them in commercials, cartoons. Remember, they used to play. They did their own rendition of "I Heard It Through the Grapevine," and they really became, since they were recognizable and they made you immediately think of. I'm not sure if it was just kind of a collective industry or if it was a particular company, but it made you think of that. So it symbolized the brand, basically, of those raisins, and so these function as a trademark as well. And I hope that makes some sense there. But ultimately, this exact item right here, protected by copyright, and also functions as a trademark. So if someone else were to use, say, some kind of similar figurine for another raisin company, a competing raisin company, possibly even a grape company, maybe it's kind of a related industry, there might be a claim of maybe not copyright infringement because maybe the raisin's not substantially similar to this one, but if the raisin were to cause consumer confusion as to source, which company is it, then there may be trademark infringement as well. So anyway, a couple little lessons here, but the original lesson being, if you come up with, you create toys, figurines, not even just three-dimensional, but say two-dimensional, copyright is probably your friend. That's the type of intellectual property protection that you need to be thinking about. If you have any questions about this video, do feel free to shoot me a note, drop a comment, and if somebody would benefit from this video, please feel free to share it. So until the next one, have a good one. Bye-bye.